Hi students, so we continue with our topic legal system. In this video we're going to look at the following subtopics: legal institutions and their functions, rights of a suspect in 1. Pre-trial, 2. Trial, and post-trial stages. So there are 3 stages there: pre-trial, trial, and post-trial. Then C, we're going to look at the procedures in a criminal case. The procedures in a criminal case. Make sure you understand this. So we start with the legal institutions. The legal institutions are those organizations or government institutions that are involved in the enforcement of the law, making of the law, or those institutions which are involved in the legal system that are concerned with anything that has to do with law are known as legal institutions. Now, the first one is the legislature. The legislature is the lawmaking body. So it is within the legal system because it makes the laws. It's the highest source of law in Zambia, or the biggest source of law in Zambia. We have the Zambia Police Service. The Zambia Police Service. These, they maintain law and order. They make sure that the law made by the legislature is being obeyed. Citizens are abiding by the law. The executive. The executive is a legal institution. Why? Because the president who heads it has the power to make laws. How? Some may say how. So the president has got the powers which we say, or which we call the prerogative powers. These are the special rights and the privileges given to the president because of the office he or she holds. Even cabinet ministers fall under what? The executive. And we learned that under the legislature, the cabinet ministers can make laws which we call the subsidiary or the delegated laws. So the executive is a legal institution. We come to the legal profession. The legal profession is simply a body of legal practitioners known as lawyers. Known as what? Lawyers. So these, they represent clients in the courts of law. They are under legal institutions. We go to the courts. The courts deal with all areas to do with law. The courts deal with all areas to do with what? With law. So this is why we're going to spend much of our time. We want to discuss or to know the levels of courts that we have. The levels of courts. So there are 4 levels of courts in Zambia. What are those? We have the local courts. 1. The local courts were established by an act of parliament. Local Courts Act of Zambia, Cap 29. Cap 29. They are almost found in every district of Zambia. Every district. They hear about 500,000 cases in a year's proceedings. Now, these are the most easily accessed courts in the country because they are many and relatively cheap. They are cheap, the local courts. They are simple. They are presided over by the presiding justice, appointed by the Judicial Service Commission, JSC, Judicial Service Commission. The ones who appoints the presiding judges. Then another important thing here is that the procedure in the local court is informal. So it doesn't need lawyers. It's very simple. It doesn't need lawyers. So you cannot take a lawyer to represent you in a local court. So that's about the local court. The magistrate court on level 2. These are also known as the subordinate courts. Subordinate courts. They were established by a subordinate act of Cap 28 of the laws of Zambia. They try both criminal and civil activities. So from the local courts, we have the magistrate court. Then we go to the high court. The high court is known as the appellant court. So let me just say the high court, the industrial relations court, and the Supreme Court are called the appellant courts. How do I mean appellant courts? They do not handle trial cases, or by that I mean you cannot start from the High Court just to take a case to the High Court, but it needs to come from the subordinate courts, which are the magistrate courts. The magistrate courts handle that case. Then if they fail, they will give you the right to apply to the High Court if you are not comfortable with the judgment that has been given. So they are called appellant courts, presided over by puisne judges. Puisne means junior. So these junior judges are appointed by the president after recommendation by Judicial Service Commission. So the Judicial Service Commission recommends, then the president will appoint. They deal with legal issues and not issues of facts. That means what the law says about a case and not facts about the law or about a case. So, because of strict conditions or the formal procedures which are in the High Court, it is advised that you get yourself a lawyer to represent you. So lawyers are used to represent clients. In some cases whereby you commit treason or murder, then you are not able to find a lawyer or to book a lawyer for yourself. Then the government can provide a lawyer through a pro bono basis. There is what you call pro bono. This is a basis whereby every lawyer needs to offer a free service, or every lawyer can offer a free service to a client. That is what we call pro bono. That's about the three courts. The first three: local courts, magistrates, and the High Court. We come to the Industrial Relations Court. I said these two courts, the Industrial Relations and the High Court, are at the same level. They are on level 3. So we have 4 levels of courts. Now, the only difference is in the cases they handle. This one, the Industrial Relations Court, deals with the employees and employer relations. No, you didn't pay me, I worked these months without getting paid. That's where you take your cases to the Industrial Relations Court. Same level with the High Court, but only different in the matters they handle. We come to the Supreme Court. This is the highest court in Zambia, headed by the Chief Justice, assisted by 9 judges. It's not a trial court unless a presidential petition. That means you cannot start your case from the Supreme Court, but it needs to come from, let's say maybe the Industrial Relations Court or the High Court. That's where the case should come from. Then it goes to the Supreme Court, unless a presidential petition whereby there was maybe rigging, or one candidate is not satisfied with the results of the election, can petition just directly taking the case to the Supreme Court. It is allowed. The Supreme Court also deal with questions of laws and not questions of facts. So it follows what the law says and not what the fact is about that case. That's how it is at the Supreme Court. Okay, so we now go to the rights of a suspect at firstly pre-trial stage. Pre-trial. So pre means before trial. Trial is when you have been taken to court as a suspect. That's trial. Now, before you are taken, what rights do you have? 1, arrest without warranty. Arrest without warranty. We say suspects should only be arrested upon police officers producing a warrant of arrest. They should produce a warrant of arrest, a document showing that it is you. It's you they want. They should provide your personal details. That's the warrant of arrest. Now, there are some cases which are allowed or which permits the police officers to arrest you without even producing a warrant of arrest. Cognizable offense. Cognizable offense is a type of offense that can be seen or that can easily be seen as a crime. For example, while it's on the street, a police officer sees a person snatching a purse from maybe let's say a woman. The officer can arrest the person without even producing a warrant of arrest. Or a police officer finds you fighting. He can arrest you without producing a what? A warrant of arrest. The second right is the arrest with warranty. Arrest with warranty. So there are some offenses for which a person can only be arrested with a warrant of arrest. Such crimes include official corruption, fraud, desertion of children by a parent, common assault, and other offenses which cannot be seen easily as crimes. They need warrant of arrest. Detention for questioning. Another right. Police have no power to detain a person for questioning unless he or she is arrested for a criminal offense and informed of the reason for the detention. They cannot just come and detain you, they put you in the police custody. No, you need to know your rights here. They should tell you the reason for detention, not just taking you to police custody without telling you anything. They should tell you the reason for detention. Compensation for false imprisonment. Compensation for false imprisonment. A person who is unlawfully arrested or detained can sue for compensation for false imprisonment through the courts of law. You just arrest someone as a police officer without even knowing anything about that person. Then at the end you find that the person is innocent. If he or she wants, he can sue the state for compensation for being unlawfully detained and arrested. Then we come to interrogation. Interrogation means questioning. So under this right, we are saying the police officers are allowed to question the suspects, but they have no powers to use force in order to draw out statements from the same suspects. No, they should not torture them. A suspect who is tortured can sue the state for compensation. Torturing is not allowed so that you get information. No. We go to judge's rule. Judge's rule requires the police to inform the accused of his or her right to remain silent. You remain silent. If you wish to say anything, the statement may be used as evidence against you during trial. So you must be very careful. The law of bail. The law of bail. A person arrested, detained, or appearing before the court may, while in custody or at any stage of the court proceeding, apply for a bail. This is simply a sum of money paid by a person accused to prove to the court that he or she will appear on the day of trial. So you need to pay some amount of money there, just to show them that I will not run away. So here there is need for you to provide what we call sureties or surety. You put a surety. Okay, Mr. Gilbert is the surety here. That means if that person runs, then I'll be held accountable on his or her behalf. That's how it is. Those are the rights of a suspect at pre-trial stage. We now go to the rights of a convict, as well as the suspect at trial stage. The first one is that the defendant is innocent until proven guilty by the court. It's innocent. The second one is the burden of proof. The burden of proof states that the prosecution should prove all the criminal allegations against the accused. He who alleges must prove. You cannot just be saying, no, Mr. Gilbert, you committed murder. How? What facts do you have? So you must prove those allegations. 3, we have standard of proof. Standard of proof. This states that the evidence produced by the what? By the prosecution, the person who has taken the defendant to court, must be beyond all reasonable doubt. It should prove the what? The case, or it should prove that the defendant is guilty. The evidence must be beyond reasonable doubt. Other rights of a convict at trial stage. So those are the 3 basic rights. Now there are other rights. 1, fair trial and impartial judge. Fair trial. The trial must be fair. The judges must be impartial, free from biasness. If a judge feels that he has got interest in a case, he or she should excuse him or herself from handling the case. You find that you are a judge, is your relative with the case, then you should excuse yourself, because you need to be an impartial judge when judging. 2, we have a right to a speedy and public trial. Right to a speedy and public trial. The justice system operates on the understanding that justice delayed is justice denied, which means that not getting a speedy trial is as good as not getting justice at all. Altogether. So there should not be delays. No court at journey, no. Right to silence. Right to silence. Since the burden of proof lies on the prosecution, the accused has the right to remain silent. When this one is explaining, you remain silent. Not he's still giving evidence. No, you see, that's not how it was. You remain silent. Protection against double jeopardy. This means that an accused person cannot be tried again for an offense of which he or she has been acquitted. For example, a person acquitted of murder cannot later be tried on a lesser charge of manslaughter. No, it was not murder. You acquitted that it was not murder. Again, you say, okay, it's manslaughter. Come to the court. No, that case has already been judged upon. Protection against double jeopardy. Protection against ex post facto law. This means the law cannot be backdated. That phrase is a Latin phrase, ex post facto law. The law cannot be backdated. That means if a person commits a wrongful act, it's a wrongful act, but at that time it is not described in the Constitution as a crime. Then as time goes on, the Constitution stipulates to say it's a crime. Then you say, no, we'll judge you or we'll try you. A person cannot be tried over that case because it is in the past. The law cannot be backdated. Ex post facto law. Right to an attorney. An attorney is the lawyer of the government. That means for those people who cannot provide lawyers for themselves, the Legal Aid Department of the Ministry of Justice, which is mandated to provide legal services to all people accused of offenses, should provide a lawyer for those people. They should provide a lawyer. Those are some of the rights of a suspect at trial stage. This is a video, so we can act a Nigerian movie if we talk about everything. So we're trying to summarize, so you research more. Those are some of the rights. Now we come to the rights of a suspect at post-trial stage. Post-trial, that means after trial, after you have been tried. The basic right is the right to appeal. Right to appeal. Just at the end of the trial, the judgment has been passed. The court will inform the convicted of his or her right to appeal. If he or she is not comfortable with the judgment, you can apply. Other rights include right not to be tried for a criminal offense pardoned by the president. So the president has got the powers to say, no, let him be or let her be. that person should not be tried over that criminal offense. The president has pardoned it. Right to have an interpreter. If a person is not familiar with the language being used in the court procedure, he or she has the right to an interpreter. Find an interpreter for that person. Person doesn't know English, take him or her in the Supreme Court. Find an interpreter. Right to be given a copy of record of the court proceedings. You know, as you are explaining, you are giving evidence there in the courts, there is someone writing, taking record of everything. So that copy must be given to you. You've got the right. Say, give me the record. So that will accompany your application to higher courts. When you want to apply from higher courts, you use that record of court proceedings in the previous court and your application. That's what they consider. Then you are done.
You are watching Knowledge World Academy. Please stay tuned.
Okay, so that was a commercial break. We continue. We now go to the procedure in the criminal justice process. The first thing to happen is the arrest. Accused taken to police custody. That's the procedure in a criminal case. Secondly is the plea. What do we mean by plea? This is the first appearance of the suspect in court. First appearance. So a charge or the matter will be read for the what? For the suspect. Now, a suspect has two options. Whether to take a plea of guilty or a plea of not guilty. What do you mean by a plea of guilty? Plea of guilty, that means he or she has accepted the charge to say, okay, yes, I am guilty. There, the prosecutor will read the facts of the case to the accused. The facts. After accepting the plea of guilty will be recorded, and the prosecutor will read the facts of the case. Facts, the evidence. If the facts are also admitted, the court convicts the person who accepts the facts. Then the prosecutor produces and reads previous records of conviction, if any. Previous records. Okay, this person in the past, again, he did this and this. So if he wants, he can accept or not. If that is done, everything is accepted, the court will proceed to what we call judgment mitigation, whereby the suspect will ask for leniency from the court. Okay, don't give me 7 years, at least do 3 years, because I've got children. I'm the pillar of the family, so at least people will be a bit safe if you give me just 3 years. You ask for leniency from the court. That's what we call mitigation. Now, if the suspect takes a plea of not guilty, you deny to say, no, I didn't do this, I'm not the one. The plea of not guilty will be recorded, and the date for trial is set. The date will be set. Okay, 25th May, you will come for trial. That's when now you apply for bails in order for you not to be in police custody until that date. So now comes trial. That is trial now. The trial stage has two parts: the prosecution and the defense. The prosecution and the defense. The prosecution is the person who takes the other person who is called the convict to court. So, firstly, the prosecution brings the witnesses. Witnesses will provide facts they know about the case. After, take this one clearly. You need to follow this process very well here. So after they provide the evidence, they will be examined by the defendant. They will be asked questions. Oh, Mr. Gilbert, is it true that you saw me getting a knife? as the witness, I'll be examined. After the defendant examines the prosecution's witnesses, the prosecutor will come in to make corrections, to mend where the evidence of the witnesses might have been distracted. Because when being examined by the defendant, maybe they would have forgotten something. So the prosecutor will come, yeah, Mr. Gilbert, remember, it's not that. He will try to mend, to maintain the evidence. After that, the prosecutor will give a summary of the many points and urging the court to convict the accused. The court will then consider whether the accused has a case to answer or not. If the court finds out to say the accused has a case to answer, now when a person has been found with a case to answer, that is called in Latin prima facie. Prima facie. Then the accused will be put on defense. Defend yourself. The accused will bring the witnesses, his or her witnesses. The witnesses will try to defend the accused. After that, the prosecution or the complainant will examine the witnesses of the defendant to ask them, what are you saying? Didn't you see how Mr. Gilbert killed that person? How he stole things from the shop there? The prosecution will try to distract the evidence produced by the what or provided by the defendant's witnesses. After that, the defendant will come in again to re-examine his or her witnesses to mend where the prosecution might have destroyed. To mend where the prosecution might have destroyed. The defense will close the case, urging the court to find the accused innocent. They will close their case and say, I am innocent according to the facts that I've laid down here. I am innocent. That's a simple process that is there on trial. After all this, the court will now proceed to what we call final submission. This is where the prosecution and defense addresses the magistrate or the court with the strong points now. Strong points. You summarize into many points. After that, the court will pass judgment. The court will deliver judgment. Now, from judgment, there will be records of previous convictions. The prosecutor will then read to the court any previous convictions. Oh, he also murdered that person. Oh, he also did this and this. The defendant will either accept or reject all those. Then we proceed to mitigation. Mitigation, as I said, defendant asks for what we call leniency. Leniency. Here, the defendant will be required to provide reasons why he or she should be given a lenient sentence, because you are now entitled to be put in prison. Now you provide reasons as to why you should be given a lenient sentence. No, I'm a pillar, family pillar. I'm my father. I've got responsibilities, so no one will take it up from there. So at least you give me 3 years. That's how it is. That's judgment. From judgment, we go to sentencing. The court sentences the accused, guided by 3 principles. There are 3 principles that guide the magistrate or the courts when sentencing the convict. One is retribution. Retribution means the court should aim at punishing the offender, especially in rape cases. The second one is deterrent. Deterrent is to prevent others from doing the same crime. Others will see, just rape case. They have given him 25 years. No, I won't do rape case. Then we have rehabilitation, to reform the offender, to become a good person. Those are the 3 principles that guide the court when sentencing the offender. That is just one process. You need to compress it and summarize it. Then you know it. Do not memorize the words, just know what happens. Use pamphlets, because here we're just summarizing, it's a video. So use the pamphlet. You try to read what really happens during trial, during sentencing. This is just a video to help you understand what you are studying. Bye. See you in the next video.